everyone to today evening's Value Talk. We have with us today Advocate Nitish Messey. Advocate Messey is an practicing Supreme Court advocate, second generation. His father is also a practicing Supreme Court advocate, and he's also an advocate on record on the Supreme Court, which is a rare distinction earned only by around 1,500 advocates in the entire nation.
Thank you for your kind words, Captain Vipul.
Right. So, for the consumption of the audience, let me repeat again. Today, the talk is centered around the precautions one should take when selling a property. The kind of problems we have seen when an investor wants to sell a property, and therefore, what kind of challenges, if we can understand them even before they arise and take measures to solve those challenges, then it is going to be beneficial to those people, to the sellers who want to sell properties in times to come or are already in between some transactions. We'll start our talk today. My first question to you, Advocate Messey, is how to protect my rights as a seller when I'm writing an agreement to sell, and what disputes arise about the title of the property.
So let me just tell you what is the title of the property. So let me just first tell you about the title. What refers to the title of a property? It is the owner's right to own, use, or sell the property, a piece of land, whatever. Is it a flat, or if it's a piece of land? So if the owner does not have a clear title to a property, they need to cure it, because otherwise the buyer can sue them, and it's not just civil damages. He can file a criminal complaint against you, saying that you have cheated the buyer because you have not revealed. What are the charges? The charges could be loans, mortgage, liens, government taxes. So you have to disclose all these things in your sale deed and in your agreement to sell.
तो आप ये बोल रहे हैं कि जब एग्रीमेंट टू सेल लिखा जाए, अगर मेरे टाइटल में किसी तरह का कोई लीन या कोई चार्ज है, आई शुड clearly mention it in the
you should do it in disclosures. That is the term we use. Agar in the simple language, you should disclose all these details in your agreement to sell and your CDD. Because if you do not do that, this can be a problem for you later, as the buyer can come back and say that you have not disclosed these things deliberately and you have cheated.
Okay. So in case any material detail which can impact the title or the marketability of the property, it should be recorded in the agreement to sell as well as the sale deed.
It should be clearly disclosed. We call it disclosure statements, as I've said. In simple language, it should clearly be disclosed in the agreement to sell and the sale deed.
Okay.
Let me add certain other things which you can, which a seller should keep in mind while selling the property. You don't give your original documents. You don't give your original documents to a broker because this can be misused. Always ask for an earnest money deposit, because this guarantees that the buyer will come to you. And please stay clear of false promises, especially from brokers.
Okay. अब इसमें एक चैलेंज ये आता है एडवोकेट मैसी की, अगर डिस्प्यूट हो, let's say the buyer gets into, I get into a dispute with the buyer. The buyer simply refuses to acknowledge कि नहीं उसका नहीं है, तो आप क्या कर लेंगे?
Generally, I think this happens more with the middlemen and brokers, not with genuine buyers. But yes, you're right. A situation like this can come. So best तो ये है कि आप you get your agreement to sell registered always, right? But somehow जल्दबाजी में कई बार होता है कि you cannot get the agreement to sell registered, or let's say you are doing it over an email or something like that, or you are not in the same town because the registration के लिए दोनों parties को आना पड़ता है. So you get the bank verified signatures of the buyer, and you note exactly the place, time, location, circumstances under which or in which the agreement has been signed. You have witnesses to the agreement. You get the signatures attested of all the parties, including the witnesses. Uh, Also, please mention, which is very important. You mention, because most of these things happen over a phone or let's say an email. So you please clearly mention the contact details of the buyer and identify the buyers and identify these email addresses. If there are multiple email addresses, phone numbers, WhatsApp number, possibly even Aadhaar card and PAN card, so that tomorrow there is no chance of you keep a lot of options to kind of identify the buyer, so that tomorrow there is no chance of him getting away by saying that I did not do this or I'm not committed to this now.
Okay. So मैं आपकी बात को अगर वापस से समझाऊं तो आप ये बोल रहे हैं ideally तो one should get an agreement to sell also registered.
Yes, that is the first thing. But somehow the challenges in getting the thing registered, then you do these things. You make your communications, or let's say your unregistered agreement to sell, in duplicate, triplicate. You have them exchanged over email, so that there is no possibility of the buyer at a later stage denying this.
So अगर रजिस्टर नहीं करवा सकते हैं तो फिर डुप्लीकेशन एंड लेयरिंग किया जाए, और जितनी भी पार्टीज हैं उनकी ऑथेंटिसिटी, उनकी डिटेल्स, उनका आइडेंटिफिकेशन एस्टैब्लिश करें और उनके सिग्नेचर्स को वेरीफाई करवाएं फ्रॉम बैंक्स या अटेस्टेड हो, मतलब उनके सिग्नेचर्स भी अटेस्टेड हो, so that at a later stage the parties cannot say जी हमने तो साइन ही नहीं किए थे.
Right. Absolutely.
So it's kind of tightening that. Okay. Now also, which I've seen in my dealings in real estate, at times the buyer says, जब उसको अगर exit करना होता है तो वो technical faults जो निकालता है वो ये होती है कि हमें तो जी सेलर ने नोटिस भेजा ही नहीं कि आप आ जाओ रजिस्ट्री करा लो, या हमें तो इन्होंने सूचना ही नहीं दी कि मेरा रेंट पे था, मैंने खाली करवा दिया. मतलब कोई भी इंफॉर्मेशन, the buyer refuses to simply acknowledge that the seller had reached out and done his bit of the agreement. So how do you ensure कि वो चीजें ना हो, मतलब buyer इस तरह की टेक्निकल वो निकाल करके, नुक्ते निकाल के, और is not able to hide behind these kind of technicalities.
So, as I've said already, for the email addresses, phone numbers, you please identify the addresses, the communications, and you kind of get it supported by some documents. Like, as I said, Aadhaar card, PAN card. PAN card में तो address नहीं होता है, but Aadhaar card or other documents, government ID.
Identify तो, sorry to interrupt you, वकील साहब, identify तो हो गया. वो कहता है जी एग्रीमेंट तो मैंने किया था, आई एम दी वन हु हैड साइंड द एग्रीमेंट, सब कुछ है, लेकिन लेट अस से जब जिस दिन एग्रीमेंट किया तो देयर वाज एन टेनेंट इन माय प्रॉपर्टी, एंड वन ऑफ द कंडीशन ऑफ द एग्रीमेंट टू सेल वाज कि मैं टेनेंट से वेकेट करा के और आपको सूचित कर दूंगा जी मैंने टेनेंट से वेकेशन करवा दिया.
This should clearly be mentioned in the agreement to sell.
हाँ, नहीं मेंशन भी कर दिया. अब बायर का मन बदल गया किसी भी वजह से, मैंने टेनेंट से वेकेट भी करा दिया, मैं बोलता हूँ जी आओ खरीदो, वो बोलते नहीं भाई साहब हम तो, आपने हमें बताया ही नहीं था टाइम से कि टेनेंट ने वेकेट करा या नहीं करा. So how do I ensure that my communication which I make to the buyer cannot be disputed at a later stage?
You communicate these things over emails. You exchange. You ask for the confirmations of the emails. You send messages on WhatsApp, and you have the address of the buyer identified, and you communicate it through registered post, courier. So all these communications have to be done at the identified address, which is already mentioned in your agreement to sell, and in the alternative, or let's say in supplement to which, you do it over emails and phone numbers, which are identified again.
Okay. तो आप ये बोल रहे हो कि एग्रीमेंट टू सेल में लिखा जाए कि किस ईमेल के ऊपर कम्युनिकेशन किया जाएगा, किस नंबर पर कम्युनिकेशन किया जाएगा, व्हाट्सएप से किया जाएगा या एसएमएस से किया जाएगा, किस एड्रेस पे किया जाएगा, उस एड्रेस पर स्पीड पोस्ट या रजिस्ट्री भेजी जाएगी, तो उसकी अगर रसीद मेरे पास है स्पीड पोस्ट या रजिस्ट्री की, so then it is a valid communication.
Right. And you identify those address in with the help of the government IDs like Aadhaar card. so that tomorrow you cannot deny.
ओके, अच्छा सर, एक और आप मेरे को थोड़ा सा ये बताएं कि कई बार क्या होता है, खासकर जब मार्केट में थोड़ा सा उछाल होता है, या व्हेन देयर आर प्लेसेस जहाँ डिमांड ठीक चल रही हो प्रॉपर्टी की, तो बहुत बार ब्रोकर्स क्या करते हैं, दे गेट इनटू एन एग्रीमेंट टू सेल विद द सेलर, कि उनका लालच क्या है। मैं आपको एक उदाहरण से बताता हूँ कि मान लीजिए 1 करोड़ की प्रॉपर्टी है, आपसे मैं बातचीत करता हूँ कि एडवोकेट मेसी मैं आपको बायर ला दूंगा और आप मेरे से 10 लाख ले लीजिए और मेरे को 3 महीने का टाइम दीजिए। वहां मेरा जो इंटरेस्ट होता है वो ये होता है कि मैं और इसको 1 करोड़ 10 लाख में, 1 करोड़ 5 लाख में बेचूंगा, तो 10 लाख जो मैंने लगाया उसमें मैं एडिशनल 5 से 10 लाख रुपए की अर्निंग कर लूंगा, ट्रेडिंग कर लूंगा, मेरा वो इंटरेस्ट होता है। आई एम नॉट द इंटेंडेड बायर, मेरे पास में वो 1 करोड़ रुपए आपको देने के लिए भी नहीं है, बट मैं एक तरह से फ्रंट रनिंग कर लेता हूँ कि आपसे पहले ही मैं कमिटमेंट ले लिया। फिर उसमें डिस्प्यूट्स कब होते हैं, जब मैं बायर नहीं ढूंढ पाता हूँ, तो फिर मैं आप में कोई गलती निकालने की कोशिश करता हूँ कि मैं इस वजह से नहीं आया, सो दैट वो मेरा 10 लाख रुपया जो मैंने आपको दिया हुआ वो प्रोटेक्ट हो। इस सिचुएशन को कैसे हैंडल किया जाए वकील साहब?
That's a nice question. In fact, this is a problem faced by especially people who own commercial properties, which I have seen. And the best way to tackle is to define and identify each and everything. First of all, if it's a broker, it should be clearly mentioned that he's not the buyer, he's a broker. And I would rather suggest in matters like these that instead of calling it a agreement to say sell or making a nomenclaturing it to agreement to sell, you rather make it a marketing agreement or an exclusive marketing, right? Exclusive brokering agreement or something like this. Because agreement to sell can be, let's say, disguised as him being the buyer, which he's not. He's only a broker. So this should be clearly mentioned there. And the second thing which should be mentioned is that which is the timeline in which he's supposed to identify the buyer and get the sale deed closed. That closure date should be specifically identified and mentioned in the agreement to sell, or rather the marketing exclusive marketing agreement. Now, what happens is that in most of the cases, it's the broker who comes up with this kind of a pre-drafted agreement and gives it to you, and you sign it right. So you please don't do it. You read it carefully, run it through an expert, a real estate expert, maybe a CA, maybe a lawyer, or anybody who's a professional at this, and you ask him to make changes or ask him to draft a agreement for you, because ultimately it's your property, right? You don't want it to get blocked, because what happens in this is the modus operandi is that they come to you with a pre-drafted thing, they make you sign it, right? And then when they are unable to find a buyer, or let's say there's a problem with the market, then they block your property and say that you cannot sell it to anybody now, because I have the agreement to sell with you. You are bound to sell it only to me. So they're very innocent home buyers who face these problems. And I think I've squarely answered this. The other thing is that what you can do is in these kind of agreements for refund, because he may come back to you for refund, right? If he's unable to find. So to mitigate the situation, you may probably come up with a percentage of refund. Like you don't forfeit the entire earnest money amount. You can say, let's say 50-50 or 70-30 or whatever is like agreeable. Or a better way, which I personally feel, is to have a interest-based earnest money deposit. If it is been there for a particular time, this is the interest on which it will be done.
Okay. So if I understand you correctly, आप यहाँ पर ये कह रहे हैं कि हम अगर इस तरह की कोई सिचुएशन है उसमें एग्रीमेंट टू सेल ही ना लिखें, उसमें एग्रीमेंट टू मार्केट या ब्रोकिंग एग्रीमेंट लिखें, ताकि इंटेंशन जो है वो चेंज हो जाए. He does not have the rights of a seller. I mean, sorry, a buyer. He has the right of a marketing agent or a broking agent or maybe a financer or something, और उसको उस तरह से लिखें so that later on वो dispute ही ना कर पाए कि मैं तो इसको प्रॉपर्टी को खरीदता. So जो मार्केट में एक प्रेवलेंट जो प्रैक्टिस है कि मैं बोलता हूँ जी मैं खरीद लूंगा एंड देन आई फाइंड अनदर बायर, उसको खत्म करने के लिए एज अ सेलर आई शुड से दैट ही दिस पर्टिकुलर इंडिविजुअल इज अ मार्केटिंग एजेंट और अ
Broker is a
ब्रोकर
marketing agent or a broker.
and I've appointed him as a sole marketing or a sole broking agent, but he's not the
For a
intended
limited
buyer
period of time. For a limited period of time.
for a
Because this is,
limited period. Hmm.
and you
तो
specifically
उसमें
you define that in the agreement.
हाँ, तो उसमें फिर वो लेटर ऑन मेरे से उस तरह का डिस्प्यूट नहीं कर सकता है कि मैंने उसके एज अ बायर उसको चीट कर लिया या डिफेक्ट इन द प्रॉपर्टी हो गया या सो माय प्रॉपर्टी डज नॉट बिकम
Block.
मतलब ब्लॉक नहीं होती है, उसके ऊपर उस तरह की वो चैलेंजेस नहीं आते.
Right.
ओके. हाउ टू हैंडल द सिचुएशन व्हेन देयर आर मोर देन वन बायर्स या मल्टीपल बायर्स, मतलब चार पांच हैं, बड़ी प्रॉपर्टी है, छोटी है, जो भी है, लेट्स से हस्बैंड वाइफ है या हस्बैंड वाइफ मदर है, मतलब दो तीन लोग हैं.
Mhm. So you clearly identify, as I've said, the buyers, the individual buyers, their particulars, their addresses. You have to get the signatures of both the buyers. It's not that I can sign on behalf, unless and until you have a registered power of attorney, right? It is always advisable to have the signature of both the buyers on the agreement to sell as well as the sale deed. You get the details and modes of communication, which we've already discussed, where you identify the addresses of communications, multiple ways of communications. You treat all buyers as separate buyers with not overlapping rights.
Mhm.
You will have, I think you provide the details of the buyers, you identify them, and you have to say that you're committed to buy the property. In case of, let's say, change of circumstances, for example, what happens is that a couple is buying, or let's say a would-be couple is buying, and they don't get married, or let's say a married couple gets divorced. So you have to mention these things, that you have to stand with your commitment even in change of circumstances. So
Mhm.
you mention these things which you foresee. So what happens is that problems will arise. The let's say the professional way of seeing it is that you foresee these problems and you give provisions of these problems in your agreement, and especially agreement to sell, because this binds the buyer, or let's say, and increases his commitment for buying the property.
Okay. I will have two more questions for you before I open the discussion to the audience. How to safeguard my interest in the seller if the agreement to sell is for a longer period, say more than 60 days, if it is 90 days, 150 days or something, then what are my safeguards? How do I safeguard my interest for long duration agreements to sell?
So ideally, I would say that it's not advisable to have long durations in the agreement to sell. The ideal period would be 30 to 45 days. Workable is 45 to 60 days. But it should not be for a longer period of time, because this gives rise to, let's say, more chance of backing out of the agreement, especially for the buyer. He may change his mind. He may find a better property, let's say, right? Or let's say he may lose his job, right? Or his uh, application for loan has not been approved. Anything, right? So it's always should be for a shorter period of time. Uh, there should be systems like letter, emails, communications to remind the buyer in this period of time. The best way, which I think, to tackle this situation of a long duration agreement to sell, is to have something called the interim payments. That you say that, all right, it is for 60 days, but in every 20 days, you make 30% of the payment. So this kind of increases the commitment of the buyer. In every 20 days, he's more committed because he's now put his money there. He's put the earnest money, now he's put another 30%, then another 30 in the next 20 days, and last tranche will come in the third this thing of 20 days.
Okay.
So
That not always be possible if there is a loan or something, but हाँ at least वो अपना portion तो pay कर ही सकता है तो
right, you're right.
So अगर duration agreements है या normal भी है, if we have intermediary payments coming in, then we are safeguarding our interest as sellers more because buyer का commitment increase हो रहा है.
Absolutely.
दूसरा there should be mechanisms to send reminders और जैसा आपने पहले बताया कि किस तरह से रिमाइंडर भेजना है वो ऑलरेडी एग्रीमेंट्स में लिखा हो so that reminder becomes a valid reminder कि आपकी इस दिन रजिस्ट्री है आप अपना तैयारी करवा लीजिएगा. I hope you have got your funds arranged and things like that.
Yes, and you please CC your witnesses also in these emails, right?
Okay, see the witnesses also.
Yes.
Okay, wonderful.
You always
Sir,
have witnesses who know you, and you identify the witnesses also with their Aadhaar card and with their personal identification cards.
Understood. अब सर सारा आखिरी बात ये सब कुछ हो गया. बायर ने आकर के मेरे को चेक दे दिया, रजिस्ट्री करा दी या डीडी दे दिया, रजिस्ट्री करा दी और वो अपना सेल डीड लेकर के रजिस्ट्री लेकर चला गया. मैंने अपना चेक अकाउंट में डाला या डीडी अकाउंट में डाला और बाउंस हो गया. सो मेरा सेल कंसिडरेशन ही मेरे को नहीं मिला.
Yeah, it's not a common practice, but what happens is that he may come up with a fake DD, right? So to tackle the situation, first, there's no need to panic then, because what you can do is you can go to the registry, show them that, look here, this is the check or the DD which is bounced, right? Or it is fake. I've registered a police station, a complaint with the police station as well, right? You please cancel the sale deed. Your sale deed will be cancelled in this situation. Also, to mitigate these kind of situations from arising, you ask the buyer to get your DD or check, banker's check, or whatever it is, verified from the issuing bank, right?
Okay.
So this kind of mitigates your chances of having a situation like this where your checks are bounced or your DDs are found to be fake, things like that.
चेक को या तो वेरीफाई करवाएं और अगर बाउंस हो जाए
आप इशूइंग बैंक से वेरीफाई करवाइए उसको.
इशूइंग बैंक से वेरीफाई करवाएं और अगर बाउंस हो जाता है तो सेल डीड को कैंसिल करने का भी कानून में प्रावधान है.
Exactly. Your sale deed gets cancelled if you have not received your sale consideration or your check which has been issued has bounced.
तो सेल डीड ऐसा, हाँ मतलब सेल डीड ऐसा कोई पत्थर में लिखा हुआ डॉक्यूमेंट नहीं है जो रीसाइन नहीं हो सकता है.
Right.
I have created a small slide. I'll show you, which is to 2-3 slides to help you in terms of real estate point of view से कैसे आप क्या करना चाहिए. One, this is what broadly Advocate Messey has covered. Basic 5 safeguards which you can take when you are writing your agreements to sell. Write detailed agreement. Try to record each and every contingency possible. If possible, get the agreement to sell registered, or else at least have signatures verified from banks of buyers and witnesses. 3, have short duration agreement to sell. 4, be clear in writing the nature, place, people for transaction जो Advocate Messey ने बोला, identification, so that the scope for interpretation gets reduced. Your agreement to sales are more enforceable and watertight. And जो भी आप लिखा पढ़ी कर रहे हैं उसको reconfirm कीजिए, duplicate कीजिए agreement to sell को through email, writing, etc. So these would be your 5 basic safeguards when you are getting into an agreement to sell as a seller. अब एक important बात और which is not legal but more real estate oriented कि when not to sell जिसकी वजह से problems ज़्यादा बनती हैं. तो when not to sell real estate, अगर आपका कोई project में आपने पैसा लगाया और वहां पर अगर आपका project रुक गया है, builder बना नहीं रहा है, this is not an ideal situation to sell because इसमें chances of a dispute happening are high. Besides, you will also not get the price which you expect to obtain. Second, कई बार होता है कि buyers खरीद लेते हैं, प्रोजेक्ट में पैसा लगाया और प्राइसेस नहीं बढ़ रहे हैं किसी वजह से, सो परेशान होकर के बेचने की कोशिश करते हैं, उन्हें लगता है कि हमें अब प्रॉपर्टी बेच देनी चाहिए ताकि हम इससे निकल पाए. नो, दैट्स नॉट द राइट टाइम टू सेल. एंड थर्ड इज, आपने बहुत हाई पीक रेट के ऊपर खरीदा और अब मार्केट डिप में और अब आप बेचना चाह रहे हैं, बिकॉज अगेन यू आर फीलिंग कि मैंने गलत डिसीजन ले लिया. द बेटर थिंग टू डू इन दी सिचुएशंस इज, जो प्रोजेक्ट अगर आपका रुक गया है, स्टॉल हो गया है, कुछ भी प्रॉब्लम हो गया है, सॉल्व द डिस्प्यूट्स ऑफ द प्रोजेक्ट, गेट द कंस्ट्रक्शन डन. अगर आपको एक प्रॉपर्टी बेच करके किसी तरह से पैसे की जरूरत है, तो फाइंड ऑल्टरनेट सोर्सेज ऑफ मनी. इफ द प्राइस इज नॉट इंक्रीजिंग बट स्टिल द प्रॉपर्टी इज देयर, यू कैन टेक अ लोन अगेंस्ट दैट प्रॉपर्टी इफ यू वांट मनी फॉर सर्टेन थिंग्स. और इफ इट इज जस्ट दैट आप परेशान हो गए, तो बेटर इज दैट यू वेट इट आउट एंड लेट द प्राइसेस राइज टू वेयर यू वांट देम टू बी. So what are the situations where ideally you should be making a sale in property, when to sell? If you have to meet a big financial obligation, say I purchase a property for providing for my child's education, then yes, I should sell that property. If I wanted to, I want this property to invest in a business, then I should sell this property. Second situation is when it is difficult to manage, either due to age or distance. अब अगर मैं दिल्ली में बैठा हूँ and if I have a property in Trivandrum because I was posted there at some point in time, and now I'm finding it difficult to manage because I do not have people who can do it for me, then yes, it is a situation to sell. Or maybe, I purchased a property 20 years ago, which was even in Noida and I'm in Gurgaon, but due to my age, I'm not able to manage it. Then it makes sense to sell it and buy something which is either nearby or in an asset which I can manage more easily. And third is if I want to upgrade or consolidate my assets. मेरे पास अभी 3 bedroom है, मैं कुछ और पैसे लगा करके 4 bedroom घर खरीदना चाहता हूँ. Obviously, these are the valid and ideal situations to sell. बट इसमें भी अगर आप एक अच्छा प्राइस नेगोशिएट करना चाहते हैं जहां आपको बेचने में फायदा हो, एटलीस्ट टेक 1 year टाइम, स्टार्ट योर सेलिंग प्रोसेस 1 year in advance. Do not wait for the contingency to happen कि अब मुझे अपग्रेड करना है 1 महीने बाद, या मेरे को अपने बच्चे को 2 महीने बाद कॉलेज भेजना है. 1 साल का समय दें और अपनी प्रॉपर्टी को अच्छे दाम पर बेचें.
Gotta focus on your